Hi, everyone. I'm Diane Diger, Chair of the Employee Benefits and Executive Compensation Department at Cypher Shaw.
And hi, I'm Ben Conley. I'm a partner in the Executive Compensation Employee Benefits Group at Cypher.
Well, Ben, the leaked opinion in Dobbs has now become the actual opinion, and Roe versus Wade has been officially overturned.
Yeah, that's right, Diane. And so I think it's important to understand what that means, which is that not that abortion is prohibited nationwide, but simply that there is no constitutional protection for abortion services. And as a result, whether abortions are legal is deferred to the states to regulate on a state-by-state basis. And what we've seen right off the bat is that there are really two types of bans that have come into play so far. And we're going to show you a visual aid here to help you understand what's happening where. The first types of laws that primarily went online right off the bat are these so-called trigger laws, which are laws that states passed during the Roe tenure that said if Roe was ever overturned, these laws will immediately come online, within 30 days or upon state AG action of the like. The second set of laws are what are known as pre-Roe bans, which are laws that have been on the books, some of these since the 1800s, that were never struck down, never enforced during the Roe tenure. And as a result, they're kind of just lingering out there. And it's somewhat unclear whether these laws now become effective. We're seeing some state governors in states where these laws exist attempt to challenge whether these laws are enforceable. And so that's really the second set. And then the third is sort of what's forthcoming, right? And we don't know, but the map we're showing you from the Guttmacher Institute, which is an organization that tracks these kinds of things, is identifying states where the political environment is such that you could reasonably expect that they will pass some form of abortion restrictions or bans. Now, on the other side of the aisle, there are a number of states that have or are passing constitutional protections to abortion services, or even safe haven laws, which are laws designed to protect people, organizations, et cetera, from criminal prosecution in a state that has these types of abortion restrictions.
So with that myriad of different responses across the U.S., depending on where employees live, they might have different access to their employee benefits, and which otherwise the employer would intend to be consistently available to its whole workforce. So we're seeing employers start wondering how they can respond to this landscape that we just showed you, depending on where their employees live.
Yeah, that's right. And I think that there are a couple different questions employers are asking with regard to their employee benefit plans. The first question is, does our plan even cover abortions? Does it cover all abortions, only abortions where necessary to protect the life or health of the mother, or does it also cover so-called elective or therapeutic abortions? Second question is, do we cover abortifacient drugs? Because we now know or have known that abortifacient drugs make up more than half of abortions performed in the country right now. Sort of ancillary to that is whether and to what extent the plan covers contraceptive coverage, including Plan B emergency contraceptives. Now, as compared to abortifacient drugs, with contraceptives, there's a federal law, the Affordable Care Act, that mandates that coverage. So with certain limited exceptions, the plan likely does cover those. But it's something that people are revisiting at this time in light of the landscape. And a lot of this, sort of what your plan covers, some of it's your design, but a lot of it is driven by sort of where your employees reside and the nature of your coverage, because you have a lot more flexibility if your plan is self-funded, meaning the company pays medical claims, versus fully insured, meaning there's a third-party insurance carrier that may be subject to state law and state insurance restrictions.
Right. And on the contraceptive topic, we just saw the three agencies responsible for enforcing the ACA send out guidance, if you will, that said we're concerned about whether plans are following the ACA requirements of contraceptive coverage. And I would guess that timing is not coincidental, that guidance has been issued. But this whole thing has led companies to look at, well, maybe we could provide a travel benefit under our health plan or outside our health plan to allow employees who live in places where access to abortion or contraceptive services is restricted because of state laws where they live. And, there's questions about whether we can actually cover travel benefits under a health plan. And the answer is yes. To some extent, you can cover those benefits if the travel is basically related to and essential to access the medical care. You can cover the travel expenses like airfare or mileage. And to a certain extent, you can cover related expenses like lodging and meals up to certain tax limits, or even if it's a minor receiving the services, a parent to accompany that child to receive the services could be covered under the health plan. This type of what we're seeing from employers who are looking at offering travel benefits, and by the way, some health plans, we should mention, already cover travel benefits. So you should really look at your health plan and see what's covered right now. If you don't cover travel, or if it's not as broad as from a plan sponsor perspective you'd like, you could look at adding it. And when you add it or when you describe the travel benefits, it doesn't have to be, and perhaps should not be, limited to access to abortion or contraceptive-related services. It can be a broad-based travel benefit for access to medical benefits that are otherwise covered under your plan. And there might be a number of reasons that another medical benefit's not available near an employee's home. I've had clients who cover, for example, travel for hip replacement surgeries because their employees are located in places where the network of doctors who are expert at providing that service, they're just not available where they are. So they would pay for that travel-related benefit. Really, conceptually, it's the same kind of thing, access to these restricted services based on state law as opposed to network availability, but same kind of access issues that we're looking at.
That's right. And then I think, Diane, everything we've been talking about here has been in the context of how do we offer abortion-related benefits and travel-related benefits for abortion services within your health plan, which, needless to say, is limited in scope to those people who've enrolled in your health plan. I think the more complicated question organizations are struggling with is, well, what about people who aren't enrolled in my health plan or not eligible for my health plan, right? Which, depending on the nature of your organization, could be a significant portion of your workforce. I think the short story there is that there are some other avenues to attempt to address those populations. They're just all a lot more complicated because with the health plan route, you can really just flip a switch for the most part and ask your vendor to turn on that service. Whereas with everything else, you're probably creating something custom a la carte and new. But we are seeing some organizations set up a health reimbursement arrangement outside of the health plan that is available to participants who aren't in the health plan or are enrolled in another health plan that could help them with the travel costs. Or a lot of organizations have an existing sort of employee assistance fund, which can exist to help employees with emergency life needs, right? I can't pay my rent this month, or a tree fell in my house or something like that. And we're seeing a lot of organizations expand the criteria for that fund, or they maybe not even need to because it already exists criteria that would allow employees to tap that benefit if they have an emergency expense relating to travel for abortion services. Like I said, there's some nuance in how you set those things up. It's a little bit more complicated, but we want to make sure that people are aware that those options are out there. Now, when you are covering abortion travel services within your health plan, one of the big questions that has arisen, and you're seeing this not just in the benefits context, but more broadly is, well, look, now some of these actions are criminal, and is my information protected, right? Can a law enforcement agency tap the health plan and receive information on who has received abortion services and where? When you're talking about a health plan, one important thing to understand is that most of the information held by the health plan, which could be the company, the vendor, or whatever the case might be, is known as protected health information, or PHI. And generally speaking, HIPAA prohibits use or disclosure of protected health information, except in a narrow set of circumstances. Now, it's important to understand that one of the big exceptions under HIPAA relates to law enforcement activity. And Diane, I don't know if you want to talk a little bit about how that comes into play here.
Yeah, that's right. So HIPAA PHI may, and in some cases must, be disclosed to law enforcement. This could occur, we often see most commonly if there's a litigation going on or a lawsuit and there's a court order or even a subpoena that's seeking PHI. And that's kind of a tried path. If you have a court order, you follow the court order. If there's a subpoena, you can also follow the subpoena if there's certain safeguards put in place. But there's also disclosures for requests from law enforcement, direct requests from law enforcement that are more narrow. It's not a totally open, if law enforcement asks, we have to give it. But these would include things like if law enforcement is investigating child abuse. And the certain states are in their legislation considering, giving fetus kind of personhood. So could child abuse fit into a category if law enforcement was concerned an abortion was pending or an abortion happened? It also includes reporting PHI. The HIPAA exceptions also include reporting PHI to law enforcement under state laws that might require that report. Examples in the regs are things like if you were a gunshot victim, right? You have to report, or a stabbing victim, you have to report those kind of incidents to local law enforcement. So it's not unreasonable to assume that we're going to see state laws that are going to require reporting by covered entities, HIPAA covered entities, including health plans, of, abortions, information you have that an abortion was performed, where those services are illegal. Now, granted, health plans are generally not going to be reimbursing for an abortion or contraception or whatever it is if that was performed in a state where it's against that state law. So you may not have to worry about this one, but it is something out there and it might get a little fuzzy around the edges. And finally, HIPAA also provides that PHI should be provided to law enforcement to prevent what's viewed as a serious and imminent harm to the health and safety of an individual. So again, states may view a fetus as an individual, and would they seek information from the health plan to try to stop a person from traveling, for example, because they think there's going to be imminent harm to an individual. So any request to a health plan by law enforcement for PHI related to these kind of services is going to be tricky, and really you should involve legal counsel to work through whether that's information that has to be really provided.
Yeah, and it's important to note here that we've seen the federal agencies come out and issue guidance clarifying what HIPAA does and does not do in this context. And in fact, even more recently, the Biden administration issued an executive order directing HHS to provide more information on this. But it has been interesting in that the Biden administration clearly has a desire to provide protections for abortion services and information relating to abortion services as much as possible, but they're limited by the scope of the law, right? So this HHS memo that came out effectively said, here's how you can fight requests for disclosure for information relating to abortion services, but very small print at the end essentially conceded that, but if there's a court subpoena, there's not a whole lot you can do to fight it at that point. But HIPAA's not all that's out there, though, Diane. Do you want to talk a little bit more about state laws?
Absolutely. I mean, it is important to note that HIPAA specifically says it does not preempt state privacy laws that are out there. And these state privacy laws could be broader than medical information as well. They could any kind of PI, personal information, like financial information as well. So states may provide more protections than HIPAA, ironically, in certain situations, to shield health information from disclosure.
Right. Yeah, and I mean, I think that the one key takeaway for me in all of this is that I'm seeing a lot of employers come out with announcements that may include a broad generalization, such as "Don't worry, your information is safe and protected from prying eyes of law enforcement." Just be careful about that, right? Because depending on the state, that may be the case, but it's not always uniformly true. And I think it's important to make sure that you're not misleading your employees regarding what information they may be subjecting to disclosure by taking advantage of your travel benefit. So Diane, final topic here, I think the one that everybody wants to know about, what are my risks by implementing these types of benefits?
Right. We talked about, are you going to provide benefits within or outside your health plan? And a benefit of providing this kind of benefit inside your health plan, everyone thinks, I don't know if I want to be subject to ERISA. But if you are subject to ERISA generally preempts state laws that attempt to regulate benefits, that relate to benefit plans. So if employers who are sponsoring self-insured or self-funded health plans, that employer would be free to cover the cost of any medical expenses it desires that they want to cover, arguably even where a state law has said that's not available in this state. The limitation to that, though, is that ERISA preemption does not apply to insurance laws, state insurance laws. So if you have an insured plan instead of a self-insured plan, fully insured versus self-insured, then you might not be able to preempt those state laws. And depending on the state where the underlying insurance policy is written, that insurance policy may not even be able to be written in a way that covers these kind of coverages, or much less travel expenses, the underlying medical services themselves.
Yeah. And the other big category of things that we have concern about here, beyond civil laws, which, as Diane noted, there's a pretty good preemption argument there, are criminal laws.
Right.
And notably, when you look at the scope of ERISA preemption, it ends at criminal laws of general applicability. And in the universe of abortion-related laws that are out there right now, it's relatively safe to categorize them all in that bucket. In other words, there are state laws that generally criminalize performance of an abortion service, aiding, abetting with that performance, et cetera. And they don't say it is criminal to cover abortions under an ERISA plan, pay for travel under an ERISA plan, et cetera. So they are of general applicability and likely would not be preempted. Now, all that being said, when we look at the laws that are out there today, some of them do have pretty broad-based aiding and abetting provisions. But upon our review, we think that most state prosecutors would be stretching to attempt to apply those toward an employer who pays for abortions in a state where those abortions are legal, via their health plan, or potentially who pays for travel. But Diane, do you want to talk a little bit more about the travel piece?
Yeah, I think it's important to note from a constitutional standpoint, it's not clear that a state would have any authority to try to regulate an individual's travel outside their state to another state, or, related to that, to prohibit a company from helping to pay for that travel to another state. Even in the majority opinion, there's a concurrence by Justice Kavanaugh, who goes out of his way basically to say that a ban like that on travel, from restricting pregnant women from travel, would be unconstitutional. And he described that question as an easy bar, that restriction would not survive a constitutional challenge. So given his position, and probably that of Justice Roberts, it's unlikely that a ban would get the support of a majority of, at least as currently configured, the Supreme Court. Adding to that is comments by Attorney General Merrick Garland, who also indicated he does not believe that type of ban would be constitutional, and he would, enforce it in that way, or try to stop its enforcement, I guess I should say.
Yeah, well, we've covered a lot today. Certainly not everything, because this is a topic you could drone on about for a long time, but I think we've tried to hit all the highlights for you. And
it's certainly an evolving topic as states, we looked at that map earlier. That map is going to change dramatically, we think, over the next few weeks and months. It'll be interesting to see what the federal government does. Ben mentioned earlier the Biden administration's executive order, which is, as of the date of this recording, is pending. And the various agencies that regulate the benefits area. So we're tracking it. I think it's important for organizations to stay nimble, but we really appreciate the time to share our thoughts here. Yeah, thanks for listening.